That breaking news this evening. It has been 5 hours, over 5 hours of following proceedings from the Milimani Law Courts, that 5-judge bench dealing a huge, major blow to the Building Bridges Initiative. Numerous issues have been raised. Crossfire continues this evening. We will canvass all of this with my guest this evening that I have in studio. I will be speaking in a little while. William Kabogo, who's a pioneer governor, Kiambu County. We'll also have TJ Kajwang, who's the vice chair of the Justice and Legal Affairs Committee. He's here as well. Bonnie Halole, who's the former senator of Kakamega. They're all with me in studio. But before we take a break, I want to quickly cross to constitutional lawyer Kamodo Waiganjo, who joins me live. Sir, thank you for making time for Crossfire. I mean, this is a lot. I mean, imagine you're still taking it all in, as many Kenyans are. But what for you has stood out? What do you make of all of this? Because pretty much BBI has been completely torn apart.
Without doubt, Sophia, there's no question that this is a major judgment. It has huge implications on the process. But I think we need to remember that this is just phase one of what is going to be a 3-part series. This matter would definitely end up in the Court of Appeal. It will definitely end up in the Supreme Court. So it's early days. But having said that, this is fundamental. And I think the place to start is that when we passed a new constitution, we wanted an independent judiciary, and not a judiciary that we would always agree with, but at least a judiciary that we knew was not subservient. If there's anything this bench has done, is to say it's not subservient to the executive. And if you are to compare, for me, if I was to choose between a subservient judiciary and one that gives a decision I don't agree with, I'd rather have one that gives a decision that I don't agree with. So I think it's important to then say that in terms of intellectual soundness, the judgment is fairly well reasoned at an intellectual level. I have no doubt that it's going to be a judgment that's going to be quoted in many jurisdictions in terms of its content, its approach on issues, its interpretation of the process of constitutional amendment, and all that. Having said that, there are certain things that I think the court went a little far, and which opened it to 2 issues. One is the possibility of accusations that it is revisiting. And the court has to be aware of that. And I think it also opened avenues for the possibility of reversal on certain issues. But that is generally because in the nature of litigation of this nature, of course, there will be disagreement in terms of interpretation. But in terms of the philosophy of the decision, it is very consistent. If you follow what the court argued and the place where it placed the Constitution of Kenya 2010, and therefore how you move from where we are to an amendment, the philosophy of the judgment is consistent. But there are some issues that I think raises troubling questions. And Sophie, if I would to, and it's early. I mean, this has been a 5-hour decision, so one is still thinking through. But I think there are fundamental questions. And one of the first ones is, can you stop the people of Kenya from amending the Constitution? What is so sacrosanct about what we did in 2010 that we now are bound for life on that position? When did this become, the law of the Medes and the Persians, or the Bible, that it cannot be amended even by the people? Even if the people of Kenya said and decided that they cannot change. That is a little troubling.
Why, Ganjo?
Then the question...
If
yes.
I might just interject, amending is not the issue here. It is how this process, how it began. The president is who we're hearing significantly indicted in that judgment, that he, in essence, tried to hide behind a people initiative, but this is the president, and that there are clauses that allow him to, through parliament and all these other avenues, to bring changes to the constitution, but that this was not the people's initiative. This was not Wanjiku. It was Raila and Uhuru Kenyatta.
That's a distinctive issue from the basic doctrine question. You see, the question of the process of how you get there. But the court seemed to indicate that whichever route you go, there are certain amendments that you cannot amend. So that even if this had been our JICO-led initiative, you still would not be able to amend certain provisions of the Constitution. That is troubling. The question of how this process came about, what defines a popular initiative? Is a popular initiative by the initiator or by the process in which it becomes a popular initiative in terms of involvement of the people? I think that is going to be a question that will be determined at another forum. the question of IEBC and the quorum, the constitutional minimum number of commissioners is 3. When you place a statutory process, a statutory requirement of 5 commissioners, and say that what they have done is unconstitutional, that is problematic. And don't forget that IEBC has made fundamental decisions in the last couple of months. With that, in fact, in the last 2 years, what do we make of the decisions they've made? So I'm just saying that there are issues. It was a well-argued judgment, but there are issues, I think, which opened the judges to the possibilities of reversal.
All right. Thank you very much, constitutional lawyer Kamodo Waiganjo, making time for Crossfire. Key takeaways from what you're saying: it's not over until it's over. To expect an appeal in coming days, that it's a well-reasoned judgment in your view, as well as talking about overreach. And is it a revisit of that revisit the president had talked about? Remember, we're going to take a quick short break right here on Crossfire. We'll be right back. A lot to discuss, a lot to take in. Talk to us at Sophia Wanuna, at KTN News KE. We'll be right back.